Hello and welcome to what we hope will be a series of podcasts and other short little videos we put online along with our other videos discussing some relevant legal topics that are important in Maryland agriculture. Hi, my name is Paul Geringer. I'm the Extension Legal Specialist here at the University of Maryland College Park in the Department of Ag and Resource Economics, and I'm a part of the Ag Law Education Initiative. The Ag Law Education Initiative is a collaboration between the University of Maryland's Carey School of Law in Baltimore and then the College of Agricultural and Natural Resources here at College Park that I'm a part of, and then through the University of Maryland Extension System. We bring in the University of Maryland Eastern Shore School of Agricultural and Natural Sciences. Our website is there. We're on Facebook, we're on Twitter. The website will be down in the description so you can find us more easily. So if you'd like to click on this and see what more topics we have available, please take a moment and check out our website. I'll bring up one more website here a little bit later that we also are a part of. The University of Maryland Empower is what provides us with our funding, and this is a collaboration between College Park and Baltimore to help bring together innovative programs to work together in biomedical information, bioengineering, public health. We're focused on ag law, and you can see the website there if you would like to learn more about the Empower programs. Finally, I need to give my normal disclaimer. I am an attorney. Nothing I say in this podcast should be construed as legal advice. I'm just providing you with general information. I'm glad we're all good with that. I can see you all out there in the internet world shaking your heads, so let's just continue on. So we need to talk about first what right-to-farm laws are. Right-to-farm laws are designed to protect agricultural operations from nuisance suits. The basic idea when we started with right-to-farm laws was the idea of a codification of the coming to the nuisance defense. And the idea behind the coming to the nuisance defense was that you potentially had lived in the area, had developed your ag operation, which potentially could be a nuisance, and then non-ag people moved in. Well, they were on notice when they moved in that they should have known that there was a nuisance potentially available based on what ag does. We had seen this used in some other contexts previously, but right-to-farm laws were a way to codify this. It's an affirmative defense. It means that you have to, utilize it prior to trial, at trial, and if you lose and you have to appeal the decision, you can't bring it up on appeal. It's basically use it now or lose it type defense. We have a lot of these in law, but this is a good example of one that will impact a lot of producers around the country. And all 50 states have some variation of this law. They all depend on what state you're in as to how they're going to operate. They all typically work in a way that if ag was established first and then non-ag moves in, it's providing a defense. But how it goes about doing that all depends on the state that you're in. So first we need to talk about what is a nuisance. A nuisance is just a condition or situation such as a loud noise or foul odor that interferes with the use and enjoyment of property. And they come in two kinds, public or private. Private's easiest to explain. You may have a neighbor that plays loud music. You may have a neighbor that mows his or her yard at 3 o'clock in the morning. These would be examples of a nuisance. They're doing something that interferes with your use and enjoyment of property. Public nuisance involve a lot more people than just you. It can involve a neighborhood. It can involve a community. We're going to talk about later on. We have some posts up about life before right-to-farm laws, and some of those were public nuisance examples to where farms had grown and neighborhoods had grown in towards the farms to where it potentially created a public nuisance because of the number of people impacted. I put up a picture of a hoarder's house. This could potentially be a public nuisance. Other examples would be someone dumping into a stream or creek that pollutes a water source for others. Burning could be another example. But as we talk about these right-to-farm laws, they're very limited in scope. They're only going to provide a defense to nuisance claims. They're not going to provide a general defense to everything ag does. And we need to remember that. But that nuisance claim defense is a very powerful defense. It's designed to discourage neighbors from suing farmers. It allows farmers to use good management practices to prevail in nuisance suits. And at the same time, it puts residents on notice that good ag management practices are reasonable activities to expect in ag areas. We're going to talk about Maryland's law has a disclosure provision and that a lot of counties have adopted that require new property owners, when they buy the property, to sign a piece of paper that says they understand ag goes on in this area and they understand that good management practices are reasonable activities. So we're going to talk about ways that at least Maryland's law at least tries to make you aware of this if you've never lived in an ag area before. Maryland's law has these three features. It provides a traditional affirmative defense to nuisance suits. At the same time, we're one of the few states that allows counties to develop their own right-to-farm ordinances that work in conjunction with the state law. And then we also require mediation or local review before a nuisance claim can be heard by a court. So we need to talk about this a little bit, how Maryland's law applies. So Maryland's law is only going to apply if certain conditions are met. First is you have to be an ag operation, silviculture operation. So this means you're either going to process crops, you're going to have some on-farm production, or you're going to harvest, market of any agriculture, horticulture, silviculture, apiculture, or product that is grown or raised or cultivated by the producer. You have to have been in operation for 365 days. And then you have to be in compliance with all applicable laws, regulations, and permits. Like I said, it's not a general get-out-of-jail-free card. It is a limit to defense, and part of the defense is you have to be in compliance with environmental laws, nutrient management requirements, other planning and zoning. So prior to bringing the suit, the complaint is first going to have to be heard by this Agricultural Reconciliation Board, which is in some counties, or if it doesn't, there's an Ag Reconciliation Board in the county, it would be heard by the state's Ag Mediation Program, the Ag Conflict Resolution Service, which is run out of MDA. You can find a link to their website on our website to help you out. And like I point out a lot of times, the affirmative defense is great, but it doesn't automatically end the suit. We have to go through potentially pre-trial, trial potentially to get this out of court, which means time and money for both of the parties. Local review or mediation is going to help keep those legal costs under control. It's not going to waste your time. And at the same time, because we're going through this mediation process, we can potentially work out better solutions in this informal setting. The important thing to note here is that if the county board or mediation program hasn't heard the claim first, then the state court has no jurisdiction to hear the case. So the state court can even take up the case until this mediation process works out. So it's an important feature of the law that a lot of people need to be aware of. The other thing that I pointed out is, Maryland allows counties to develop county ordinances. If you go to the Maryland Ag Conflict Resolution Service that's linked up on our website, you'll find that they have a chart that shows how each one of these county ordinances operates and what the features are of each one. They're each a little different. We just try to do a generic overview of them here. But 22 of the 23 counties have similar language in their RTF ordinances, and I call this the common ordinance. Typically, it requires the ag operation to utilize generally accepted ag management practices. What this means is, typically it's going to work hand in hand with this state law requirement that you be in compliance with all laws, regs, and permits. The idea is, if you're using these generally accepted practices, you should be utilizing practices which would keep you in compliance with laws, regs, and permits that you have to meet. To determine what those accepted practices are, we look to what University of Maryland Extension says. We look to what the local soil conservation districts have said are generally accepted ag practices. If it's not defined as generally accepted, we assume it's generally accepted, but the person complaining can present evidence to show it's not generally accepted. This seems to be a fair trade-off because it does require the person complaining to show it's not, and not put the person utilizing the practice on the defensive to have to prove everything they do is generally accepted. You have to go, if you're the person complaining, you should be the one that has to show in many cases that these things are not generally accepted. The other thing that some of these laws do, and you can see this on the chart that MDA has available on their website, that there are many of these require disclosure of not only the RTF state law, but the ordinance are in existence whenever property is sold in the county. So if you buy a new home in the county or you buy a used home in the county, you're going to have to learn about these laws in many cases. I've been working with Maryland Department of Agriculture and Maryland Farm Link to go around and educate realtors on this so they can better make their clients aware of this when they're buying new property. So if they come into the situation automatically knowing it exists, they may be able to work with the local farmers to, minimize some of the disputes that could arise in the area. Not always going to work, but sometimes it might. Some exclusions to the right to farm defense are it doesn't give you, a defense for violations of federal, state, or local laws, regulations, and permits. That's something good to take into account. It's limited to nuisance suits. We have some court cases in other states that say it's only going to apply to the nuisance caused by the ag operation and not other businesses the farmer may be running. In that case, it was an agritourism operation where the farmer was having concerts that went on the property and other excursions that we normally would not see in a farming operation. So it may not apply to those other non-ag businesses. We're not entirely sure yet in Maryland. This Alaska case is just really good to point out because the guy really was a hobby farmer. He really wasn't ever trying to sell a commodity. He would, potentially try to work the ground every year to grow a crop and then never exactly got through it. And then he figured out eventually in the eyes of the court that he can make more money storing septic waste on the property than actually farming it. And he was trying to utilize the defense as a way to protect himself from this side business he was running. So that's another case where it may not always apply in Maryland as well. It may not apply to people who are just trying to use the right to farm law to protect another operation, sort of like what we talked about above. The other thing to point out, and we hear this a lot, is these laws do take into account public health. Public health is a requirement in that local state, local law regulations that you have to be in compliance with. One is public health. Many of the counties require their county public health department to go out and investigate claims that it violates public health. And in a lot of cases, they would then go check with University of Maryland Extension staff to determine if the operation is using generally accepted ag practices or what exactly is going on. The other thing that it will not provide a defense for is negligence. Negligence is just a failure to exercise a standard of care we would expect from a reasonably prudent person. If this was a negligence presentation, I would have a picture of Ned Flanders up there because we really don't have a true reasonable and prudent person. It's a mythical person. It's just the way we all expect ourselves to act, much like Ned does in, The Simpsons, if you watch The Simpsons. But my example is almost always you have cattle on your farm. The fence keeping the cattle off the road is not in good condition. You don't do anything to fix it. One day your neighbor is driving down the road and hits a cow that's wandered off your property. This is a case where we probably have negligence. There's a lot more factors I can't, describe in this case. But the thing we need to realize is that because of this, because we would expect a reasonable and prudent person to fix their fences and keep them in good condition, this is probably a violation of that standard. And the right to farm law isn't going to apply in those cases. Like I said, it's a very limited law in the defense it provides. So what are the resources we have available? We have a fact sheet available that kind of goes in a little more detail than what I'm talking about here today to help you out. The other thing to point out is we also have this Maryland Risk Management Education blog at aglaw.umd.edu. I'll also provide this link in the description section. And we have a Right to Farm series, so as issues pop up with Right to Farm laws, we typically cover them in this. You can also sign up on the front page when you go to this aglaw.umd.edu. On the front page there'll be a box to sign up, put your email address in, and you can get updates from the site to when new information becomes available on it. So what are the conclusions? We need to talk about, again, we've talked about how it's an affirmative defense to nuisance claim. The idea is to protect farmers from nuisance claims from neighboring property owners when the farmer is using generally accepted ag practices. It's not going to protect them when every, possible claim that's going to come up. It's only nuisance claims. All nuisance claims are going to be heard first by this, some sort of local review or mediation. And at the same time, we allow counties to develop their own disclosures. So you need to check with your county to see what type of provisions they provide in each one of the counties in Maryland. And again, Maryland Department of Agriculture has a very good chart showing the different features of the law until it shows you where they're located at in the county code. Thank you for your time. My contact info is up there. My number is 301-405-3541. You can follow me on Twitter at lawpaul, or you can email me at lgoering@umd.edu. Thank you for your time.